This video is for informational purposes. It is not legal advice. You should contact your local Citizens Advice to get help with your particular issue or problem. To find your local Citizen Advice, visit www.citizensadvice.org.uk. Hello, Adam from Citizens Advice East End here. Welcome to the second of our videos about employment rights. In this video, we will be following on from our first and showing you how to apply the tests to work out your employment status. Before we start, let's recap on the takeaways from the first video. If you haven't watched that, we would strongly recommend you do so before continuing. In the last video we discussed, firstly, that your employment status is not decided by you or your employer. Instead, we discussed that what matters more is the nature of your work more than what is in writing. Therefore, you need to ask yourself, is there personal performance? That is, do you need to do the work, or can you send someone else? Is there a mutuality of obligation? Are you always going to get work? Is there control? That is, how far are you essential to your organisation? Something that we didn't cover last time in detail, but is important to understand going forward, is that your tax status is not the same thing as your employment status. That is, regardless of whether you've registered yourself as self-employed with HMRC, it is these three tests that matter. Please also remember that this is only a rough guide. Employment status is complicated, and you should seek additional advice before taking any further action. In this second video, we will be covering how you decide which employment status you fall under and what rights you have as someone who is genuinely self-employed, a worker, a LINB worker, or an employee. Let's turn firstly to the status that attracts the least amount of rights, self-employment. The first thing to understand about being self-employed is that the fact that you have told HMRC you are self-employed, and even if you have an accountant, or even if you filled in a self-assessment every year for the last 20 years, this does not define whether you are self-employed. It's everyone's individual responsibility to make sure that they pay their tax, no matter what employment status you have. This is the same even if you are an employee on a pay-as-you-earn or PAYE system. However, the absence of PAYE doesn't define whether you are self-employed. The little relevance it has was referred to in passing in video 1 for control. That is, if you are on PAYE, this shows you are slightly more integrated with the company. What matters is therefore whether any of the tests apply, and it is only if you cannot show that there is personal performance, control, or mutuality of obligation that you will be genuinely self-employed. Unfortunately, if that is the case, then you will have no rights in the employment tribunal, and you will only be able to make a claim in the county court for either a breach of contract or discrimination. The overlap between breach of contract claims at the employment tribunal and at the county court will be dealt with in a further video. Although we will cover discrimination as well, this will be a focus on discrimination in the employment tribunal, not the county court. Turning now to workers, and it should be noted from the outset that a lot of people who have been told they are self-employed may very well actually be workers. If you can show that there is either control or personal performance, although these will often both be present, as they usually go hand in hand, then you are potentially a worker, not self-employed. This is important to know, because if you are a worker, as of April 2020, you are now entitled to at least, but not only, the following rights. The right to a written contract. This used to only apply to employees, but as of April 2020, this now applies to workers as well. Some employers may be unaware that you are now entitled to this, even if when you started you weren't. Failure to provide this attracts additional compensation on top of other potential claims at the employment tribunal. The right not to have your wages deducted. If you are genuinely self-employed and you're not paid wages, then you have to claim breach of contract. If you're a worker, then you can take the easier route to the Employment Tribunal and claim deduction from wages. This will include times when you are not paid at all, which are considered a 100% deduction from wages. The right to paid holiday. In addition, you are entitled to paid holiday equivalent to your working week, either 12.0% of all your working hours or 5.6 multiplied by your working week. Although we'll be doing a separate video all about holiday pay, please for now know that employers should not be including or rolling up holiday in your pay. This is unlawful, and if this has happened to you, you should seek professional advice for assistance. Statutory sick, maternity and paternity pay. As a worker, you are potentially entitled to minimum or statutory payments for sick leave, maternity leave or paternity leave. I say potentially because entitlement will also depend on other factors like your earnings and length of employment. Please see the Citizens Advice website for more details if you think you are a worker and want to know if you meet the conditions for entitlement. Protection from whistleblowing. Again, we will be doing a separate video all about whistleblowing. But the important thing to remember is that as a worker, if you think something is wrong in your workplace, for example, you think your employer may be embezzling or there is a health and safety issue, you are protected as a worker if you raise a concern about this in the public interest or blow the whistle. The rules around this are complex, however, and you have to raise your concern in the right way to get this protection. Please therefore seek professional advice before raising a concern. There is more than one way of establishing that you are a worker, other than the test that we've outlined. One of the other ways is termed the LINB Test, after the subsection of the Employment Rights Act 1996 that established the test. To satisfy this test, you need to show that you are, firstly, that you're performing the act personally. This is broadly speaking the same as the personal performance test that we've already covered. Secondly, that you are performing this work as an individual. That is, you're not a customer or client of someone else providing services. Finally, that this is further to a contract of employment. Remember, contracts of employment do not need to be in writing. Finally, then, employees. And you can only show you are an employee if you meet all three tests. That is, you have to show that as well as control and personal performance, there is a mutuality of obligation. That is, if you remember, that you are guaranteed work. If you can show you are an employee, however, you have all the rights of workers that we have mentioned before, plus the right to challenge any dismissal. To be clear, workers can't technically be dismissed. A worker isn't guaranteed work, so if none is supplied, even if the contract is at an end, this is not a dismissal. It is simply not giving you any further shifts. Employees, however, are entitled to minimum notice. After 1 month, employees are entitled to minimum notice or warning, unlike most workers, before they are dismissed. Challenge automatically unfair dismissals. As an employee, you can also challenge your dismissal if it was for an automatically unfair reason. We will be covering those reasons in a further video. After you have been an employee for 2 years, you will gain additional minimum rights. The right to challenge dismissals as unfair. After 2 years, you will not need to show the reason was automatically unfair to be able to challenge the dismissal. You will only need to show that there was not a fair reason, or alternatively, that an unfair procedure was followed. The right to a written letter of dismissal. After 2 years, if your employer does not provide a written letter of dismissal, you can claim up to 2 weeks' wages compensation if this is then not provided upon your written request within 14 days. So to sum up, first, your status tells you what your rights are. Once you've applied the test and you think you know what your status is, the important thing to remember is what rights you do and don't have. Second, there are 3 main employment statuses. Genuinely self-employed. This only applies if you do not satisfy any of the 3 tests and is not defined by your tax status with HMRC. This status has very few rights. Worker. The easiest way to decide this is to see if you satisfy some of the tests. You will still be a worker, however, if you are not guaranteed work. They have many more rights than someone who is self-employed. Employee. The status that attracts the most rights. You have to show all three tests apply, the key one being that unlike workers, you have a right to be given work. Remember, there is more than one way of showing that you are a worker. Don't forget the possibility you are a LINB worker. Finally, remember, just because you are not an employee does not mean you don't have rights. Always check your status and see if you might have more rights than you think. We hope you found this video useful. The next is a 3-part series on dismissals.